Mr. Feldman, good morning.
Good morning, Your Honors. May it please the Court, my name is Joel Feldman. I'm representing Bobby Brown, who's the plaintiff and the appellant in this case. Mr. Brown today is asking this Court to uphold its recent decision in MBTA versus MCAD and rule that F.L. Roberts in this case cannot prove an undue hardship in the absence of engaging in interactive dialogue with Mr. Brown, who is an employee at the Jiffy Lube in Hadley, Massachusetts, a fast oil change facility. He raises two issues before the Court today. The first is whether an employer such as F.L. Roberts can fail to engage in an interactive dialogue before automatically being given summary judgment in an undue hardship case. And second, whether F.L. Roberts in this case should have been granted summary judgment when they provided no facts before the trial court to show that they would suffer an undue hardship if they had engaged in the dialogue with Mr. Brown and if they had provided him with a reasonable accommodation.
Why isn't this just simply a reasonable accommodation case? I mean, there are two forms of accommodations that could be had here. One is to exempt your client from the dress code policy or the clean shaven policy. And second is to transfer into a job where he wouldn't have customer contact. And isn't that exactly what they did? Those are the two alternative accommodations available. They don't have to do both. They don't have to prove that somehow both of them would be an undue burden. Why isn't this such a straightforward, reasonable accommodation case?
I'm sorry, Your Honor. I don't believe that they provided either an exemption or a transfer.
I thought he was permitted to work in the non-customer contact area of the business.
Right, but Your Honor, the policy from which he is objecting is not that he should be fired if he had a beard. The policy was that he was consigned to what he called the hole. That is, all of his duties were taken away from him. And he was
all of his duties were taken away?
Other than the lower bay tech duties. He otherwise, and this is in his affidavit, Your Honor, he was a cashier. He sold products. He greeted customers. He had received special training in those areas.
He was a lube technician. All of the lube technicians, I take it, did these same variety of tasks depending on the work of the day.
On a rotating basis.
Well, I just want to ask you a question, though. I thought, maybe I'm wrong, but I thought that for purposes of summary judgment, the Judge Josephson found that the hole, or that wasn't the word she used, the lower bay, was not offered and was not a reasonable accommodation. Isn't that so?
No, she determined that we had made a prima facie case, and therefore she focused on undue hardship. She had found essentially that that was not an accommodation. She focused on just the undue hardship issue. That's correct, Your Honor.
But why isn't it a reason? We can affirm her for any reason. Why isn't it a reasonable accommodation? The fact that in this is a garage. You've got people that work on the floor of the garage and people that work in the lower bay of the garage, right? We're not talking about putting this person in Siberia someplace. He's just working in the lower bay rather than the upper bay where there's customer contact. Why isn't that a reasonable accommodation as a matter of law?
Well, then the policy itself was a reasonable accommodation, Your Honor, because
correct.
Well, in other words, the policy, there was never consideration, Your Honor, that everyone who has a beard should be fired, and therefore there was a waiver of that for Mr. Brown. The policy was if you have a beard, you lose all of your responsibilities except for the lower bay responsibilities.
No, you lose all. You can't have customer contact because the policy was that only clean-shaven people would have customer contact for business purposes.
Right, but as to whether or not that was an adverse action, I guess is what Your Honor is saying.
No, I'm asking whether it's a reasonable accommodation.
Well, it's hard to imagine that an adverse action would then be a reasonable accommodation. We're claiming that it was a negative. He was essentially removed from all of his other responsibilities other than lower bay.
Which all other employees who were clean-shaven, including him before this policy was adopted, were able to do. They rotated, as I understand it, through customer contact positions in the upper bay and then the lower bay. Did he suffer a reduction in salary?
He did not, Your Honor.
Okay.
Now but let's go back. Let's assume for a second that the policy was only clean-shaven employees can work here. Similar to the Costco policy with respect to piercings. And he said, well, I have a religious problem with that. And they said, well, you can work in areas with non-customer contact. I don't think anybody could argue that that was not for the same salary, that was not a reasonable accommodation. So why isn't that a reasonable accommodation?
Assuming it's similar, Your Honor. Mr. Brown, there are no facts and evidence saying that the lower bay position was similar to anyone else's. In fact, he was the only person who was there. He couldn't take lunch breaks. There was no heat in the basement down there.
I thought all the lube technicians work in the lower bay.
The evidence is, Your Honor, that often he was the only person there. I
know, but part of the job assignment of lube technicians is to work in the lower bay as well as the upper bay.
That's correct, Your Honor, but I guess that would be analogous to saying a person with 10 different responsibilities, if you remove 9 of them and you end up with 1, that's somehow a reasonable accommodation, that's satisfactory.
It just, the problem here is the only place without customer contact is in the lower bay.
Well, Your Honor, there were other options, and that's why an interactive dialogue would have been helpful.
What other
here.
options?
Well, one is that he could have been transferred to
All right,
these other
leave
positions.
transfer aside. Transfer to another business. Let's leave that aside. I think that's pretty far out. Let's talk about other options within the business.
It's the same company.
Your Honor, the defendant is F.L. Roberts. It's not Jiffy Lube. It's one company. It has multiple divisions.
And these are each different businesses, completely different businesses, a restaurant business.
There's one restaurant. There's a
car wash business?
There's a convenience store, gas station
Yeah.
and there's also an oil change facility. There's no question that had they said there's a position available and everyone in the convenience division, and convenience store, gas station division is permitted to have facial hair. So had they told him, and he said, this is the only evidence in the record is that he would have considered it and accepted that position had they offered that. We wouldn't be here then. There was no dialogue here about, I suppose, I'm sorry, Your
Why
Honor.
does there need to be, I guess I don't know why there needs to be a dialogue if, in fact, within this business, I mean, this business about you could have transferred me to another company, another division within this company that runs a different kind of business. At least let's leave that aside. But here you either get exempted from the policy or you work in an area where there's no customer contact.
Your Honor, it's not an exemption from the policy if it is the policy. It's the imposition of the policy.
No, the exemption of the policy would be you can wear facial hair. So the two accommodations are we're going to exempt you from the policy. Does the employer have to do that? Or we're going to put you, same salary, same job, but we're going to put you in an area of non-customer contact.
Well, Your Honor, I guess maybe it's semantics, but it's not the same job. There's a lower bay tech. He had received special training in order to do the various pieces of his job. That's undisputed. He had done that for years. That's undisputed. There were no complaints. That's undisputed. He then was the only person consigned to this basement part of the job. No, he couldn't rotate anywhere else. I guess if you believe, Your Honor, that there's no negative consequence to him to having spent 6 months every hour in the basement and when no one else was doing so, then perhaps that is an accommodation. Both Judge Josephson and Judge Ponzer found that there was sufficient evidence to say that Mr. Brown had proven his prima facie case.
Proven his prima facie case, but that's a separate question from whether this was a reasonable accommodation in light of the available options to the business.
And Judge Ponzer found, as did Judge Josephson, that there were significant negative components to this.
Judge Ponzer found that a jury might possibly find that this was not a reasonable accommodation.
But Judge Josephson went farther, Your Honor. She was pretty clear that this was not an accommodation in that there were too many negative consequences to Mr. Brown. He described them in his affidavit. And as a result, it couldn't be an accommodation from a policy that he was complaining about.
I wonder if I could break in here for a moment. I'm wondering why this isn't just controlled by the Cloutier case.
Well, Cloutier, Your Honor, is a federal case that was decided before this case, before the MBTA versus MCAD case, where this court found that before you can get to undue hardship, you need to look at interactive dialogue. And in this case, there wasn't any. Mr. Brown went and said, I would like an exemption from the policy, which is to put me in the basement without any customer contact. And then the response was, we don't have time to check everyone's religion. That was the extent of the interactive dialogue here. Had they interactively dialogued, they may have been able to come up with other compromises, such as a transfer to another part of the same company. F.L. Roberts is one company with other divisions. I don't believe it would have been an undue burden to say.
Well, didn't Judge Ponzer rely on Cloutier in part of his decision?
He did, Your Honor, just as to the federal claim. Judge Ponzer felt constrained by the First Circuit Court of Appeals' decision on the federal claim, but he was concerned enough in the matter before him that he asked the state judiciary to take scrutinize this case very, very carefully. He was concerned about the impact of the decision that essentially you say the words undue hardship in a personal appearance case and you lose if you're the employee.
But the facts in Cloutier, however you pronounce it, were very different than this case, it seems
Absolutely,
to me.
Your Honor.
But I have another question. Was there evidence of that any upper bay jobs did not require customer contact?
Your Honor, that's not in the record. That would have been another compromise that we had suggested in our brief. Perhaps there were some upper bay opportunities where he'd be seen a lot less if that was a big issue, or perhaps not at all. That's not in the record.
I take it he wanted
Mr.
customer
Feldman.
contact. Excuse me, I'm sorry.
Mr. Feldman, could I ask you this question? The judge concluded that he had made out a prima facie case, right? Whose burden was it then to come forward with an argument of reasonable accommodation?
It was the defendant's, Your Honor.
Okay. Their claim here is this has a negative impact on customers, correct?
They make that claim, although we have said that there's no admissible evidence.
Well, that was my question. Could you tell me and I will ask counsel for Roberts as well, what the admissible evidence was of negative customer conduct?
Your Honor, there is no admissible evidence in that Mr. Smith, who was head of the operations for Jiffy Lube, submitted an affidavit quoting the consultant who had talked to him about why it might be useful to come up with this new policy.
Why it might be useful? I thought the consultant said that a study of businesses of this type indicated that, in fact, the more successful businesses had these policies.
Your Honor, he said every business would be more successful with clean-shavenness. That would include, presumably, the convenience stores and the filling stations that didn't implement this policy. There's nothing in the record, nor are there any documents to show that a discount oil changing facility somehow would improve sales. Mr. Roberts himself, and this is in the record, testified there was no way of determining whether or not this would affect the bottom line.
Isn't this whole consultant business a red herring? The employer is entitled to have any policies he or she wants in his or her business as long as they don't run afoul of any constitutional violations. You don't need a consultant. It doesn't matter. The employer can do whatever is legally permissible.
That's absolutely correct, and we're not saying that we should be, therefore, the court should be running F.L. Roberts' business. However, the difference is when you claim an undue hardship, you then have to come up with reasons, and that's just because there's a special protection.
So you're saying that they cannot rely on this affidavit quoting a consultant generally as evidence of undue hardship?
That's correct, Your Honor.
At least as summary judgment.
Or at a very minimum, you should be, even if it's admissible, and I understand your argument that it's not admissible, that it's hearsay, I take it that it's a fact which is controverted because presumably your client could put on evidence that it wouldn't have a negative impact, correct?
Absolutely, Your
I mean,
Honor.
we're here on summary judgment, correct?
Right. Additionally, they would have...
But did your client put on such evidence for purposes of summary judgment?
Well, for purposes of summary judgment, we said that beyond the fact that we disagree with it and that Mr. Roberts himself said there's zero evidence to show what impact it would have, that he asked for an exemption. In terms of undue hardship, they would have, it's their burden to show that if he had been given an exemption, they would have suffered undue hardship.
Well, what about Cloutier? Cloutier says the exemption from a dress code policy in a business is, as a matter of law, an undue burden.
That's correct. And if this court chose to do that, this court would be undermining its own decisions that determine that in a case-by-case analysis, you need to look at the actual, New York Motor says, you need to look at the actual business at hand, you need to look at the managerial discretion there. Additionally, in Cloutier, I should say that Mrs. Cloutier ultimately was offered the accommodations that she herself had asked for and then rejected them.
Well, there was, in fact, as I understand it, I forget they offered her, I mean, there was obviously some dialogue in Cloutier in any event, correct?
That's correct.
I mean, I seem to remember that she was offered a variety of things.
But she was offered those things that she had requested, ultimately rejected it, and that's why the court could say there was no managerial discretion because she only would accept an exemption. Although the other side in this case has tried to say Mr. Brown did that, that's not the record. The record before this case is he initially asked for an exemption. Many cases start with a request.
And the response was, well, you'll have to work in the lower bay.
That is, the response is, we're following our policy to the letter. We're not checking your religion.
But I thought all of the lube technicians worked all of the functions. So, in fact, they modified his job
Right. They took away
requirements.
every function except the
Well,
fact
they
that
modified his job requirements. He was no longer required to do cash register and customer sales and things of that sort.
Right, but those were all pieces of his job that ultimately were taken away.
Well, he liked those pieces, maybe.
Well, wait, if you're going to have a reasonable accommodation, you've got to take away something.
You got to change something.
You have to change. You have to make some change.
Sure. Usually it's the way the courts have described it is that it's a waiver of the policies that are otherwise in place. The seeing eye dog is the classic example where an employer says no dogs at the employment or in a housing context, and you have to accept the seeing eye dog. That's a waiver and exemption.
That's different. That somehow is different. Here, he's just asking to do different work so that he, I mean,
think the closer
some
analogy
change in his work.
The closer analogy might be the following. Somebody has a seeing eye dog. A consultant says, in a convenience store, if people see dogs, it'll impact customer business. And so the business says, fine, you can work downstairs, packing and unpacking, where nobody will see your dog. You can't work in the store. there's no dialogue. Isn't that that's the analogy here, correct?
I think that's correct. And Mr. Brown has put forward in his affidavit the reason why that was a negative employment action to him, and that's the policy from which he complained. We'd ask the court to vacate the entry of judgment for F.L. Roberts and enter it for Mr. Brown. Thank you very much.
Just one question. It's not just that you want a reversal of summary judgment, you want judgment on your behalf?
We don't believe that they're going to be able to prove an undue hardship on the facts before this court. Thank you.
Or a reasonable accommodation? They've reserved their right to demonstrate, to prove that this was a reasonable accommodation.
We believe as a matter of law it was not, Your Honor, but obviously
matter
we would
of law,
accept,
this was not a reasonable
we would accept a reversal, obviously, in the absence of that. Thank you, Your Honor.
Thank you, Mr. Feldman. Ms. Thompson?
Yes, good morning. My name is Claire Thompson, and I represent the appellee F.L. Roberts, which did business as Jiffy Lube in this particular case. The single most determinative fact which distinguishes this case from other state claims of religious discrimination allegation is the fact that Mr. Brown requested a complete exemption.
But you never spoke to him. I mean, that's step one. There's a lot more steps, but you didn't take any, other than say we can't check people's religion.
Justice Bodford, this court, as recently as January of 2008, in the case of MPTA versus MCAD, I believe a decision authored by Justice Cordy, specifically stated that the interactive process is not required, even in cases of reasonable accommodation, much less in cases of a complete exemption. So our position is that this is quite different, because Mr. Brown asked for a complete exemption, not a reasonable accommodation. He simply did not want this personal appearance policy to apply to him. And this is a uniformly applied policy, unlike the MBTA case, where it was very selective voluntary swapping.
Was he represented at the point that he asked for a complete exemption? Did his lawyer do it, or did he do it?
To my knowledge, Justice Greene, he was not represented at that time.
So
I believe
should we really hold that against him?
Well, he repeatedly then, in filing his complaint, Judge, in paragraph 26 of the complaint, he once again acknowledges that he asked for a complete exemption. In his affidavit, presumably
Of course he's going to acknowledge what he initially asked for.
Yeah, he
sorry,
asked
Your
for
Of
that.
course he's going to acknowledge what he initially asked for.
He asked for that, and now and he also says, if I can't get that, I want what the law, allegedly, what the law entitles me to, which is something else. What are we to make of all these amicus briefs? Practically every civil rights group, employment lawyers group, religious group.
It's really MCAD that I'm most concerned about. That's the agency that's charged with enforcing the statute. And you're not suggesting that because it's a claim of religious discrimination as opposed to disability or age or sex or gender, correct?
I'm not addressing any of the other protected
So
classes,
let me
Your
just
Honor.
ask you this question. A woman is pregnant, and she has a range of responsibilities, some of which include customer contact and some of which don't. And a consultant tells the employer, customers who see pregnant women have a negative impact on the business. And he says, fine, I'll send her to the back room, where there are computers, and she never comes into contact with customers. Okay?
No, Your Honor. And respectfully, I'd suggest to you that that's not our case. Our case is entirely analogous to the Cloutier case.
Why is it not the same? She says, I'd like to have I want to be exempt from this policy. I'm pregnant, but I think I'm presentable, and I don't think, so I just want to continue my job, which includes some contact with customers.
Because that policy, as I understand it, would be directed directly at a protected class, i.e. a pregnancy disability. This policy was not directed at religion, Your Honor. It was neutral.
It's direct. Maybe men do get pregnant now occasionally, but it's directed at all women.
If it said that all women cannot have customer contact, Your Honor?
No, it says a particular, all women, or all women who have, it's a physical attribute that there's a claim, I don't know whether it's admissible, the evidence, but there's a claim that it has a negative impact on customers. It's neutral. It's not against women. The company, in fact, employs a significant number of women. It's got women in high positions.
It's
got nothing-
against pregnant women.
That wouldn't be neutral, though. How could that be neutral?
Yeah,
Wouldn't be a neutral
that's our
policy.
position, that this was a neutral policy, and I believe that that was affirmed, the neutrality of it was
How
affirmed
can
by...
it be neutral if it has effect on a person's religion? If
Well, it's not
It's not a
directed
claim
at
of
their
disparate impact, Your Honor. Seeing an individual, a gentleman walking down the street with a beard, one doesn't necessarily associate wearing a beard or a mustache with religion. So it's distinguishable in that case. Again, it goes back to the neutrality of it. It doesn't single out religion.
But in the MBTA case,
Yes.
my memory, and yours will be better than mine, but my memory is that the bus driver in that case said, I can't work Fridays.
right.
He didn't say, I want a reasonable accommodation, did he? I mean, isn't that just a buzzword?
It's the uniformity of the application of the policy, Justice.
That's the second point you made. I think Justice Botsford is returning to the first point you made, that the single most important fact was that he requested a complete exemption was the first point you made. I think that's the
Yeah, I
point
just
to
I
which
want to get
Justice-
back to
The
that.
complete exemption, and the rest of my argument would have been a complete exemption to a neutral, uniformly applied policy that was not directed at any particular religion, distinguishable from the MBTA case, where clearly they were very selective in their application of that policy because voluntary swaps occurred regularly.
That came up in the context of what did the employer do with respect to looking into offering reasonable accommodations. And you're saying you didn't have to do anything because the first word that the employee said was, I want an exemption.
And that is specifically the Cloutier case and the U.S.
I
Supreme Court
understand.
case.
That's a Title VII case, right?
And this court, as recently as January of 2008,
We look
has
to, but you know we don't follow necessarily. Of course we look to, and you cite that, and I recognize that. I mean, there's Title VII. But in any event, on the specific issue here, 151B is different from Title VII.
Yes, Your Honor, and I would also direct the Court's attention to Judge Josephson's reliance on the U.S. Supreme Court case of TWA versus Hardison, which specifically said any non-economic impact, such as compromising public image of the employer in this case, is sufficient to establish the element of undue hardship.
Could you tell me what your evidence of negative impact on customers is, what your client proffered by way of summary judgment?
Respectfully, our position would be that it was not necessary for the judge to make evidentiary findings.
No, I just want to know
relative-
what the claim is. We have this policy because
Right.
it has a negative impact on customers, correct? Was that the reason for the policy?
The policy was based on research that the manager of that particular Jiffy Lube had taken. He had hired a consultant who had told him that he was talking about cases such as Disney World and his research that showed that customer contact employees should be clean-shaven because it improves sales, that the majority,
But there was no, but was your brother correct that the owner said there's no actual evidence of any impact on sales whatsoever?
No, respectfully, I'd suggest that that is not the case, that there was testimony at deposition of Mr. Smith that sales did increase, and that was part of the record. Moreover,
It's increased what?
I'm sorry.
After the policy was implemented? Did
After
sales
the-
increase after the policy was implemented?
Yes, Justice Cordy. There was testimony in Mr. Smith's deposition, Richard Smith's deposition, to that effect. There was documentation that showed that the sales had increased.
Yeah,
Can
but you
I
don't
ask
know.
you that? Go ahead, Justice Green.
Well, you don't know if that was as a result of the policy or whether they were given coupons out saying, two oil changes for the price of one. Or
That is true,
so
Justice
that's
Green.
a kind of a.
Yes, that is true,
you-
but it keeps coming back to what...
I take it your legal
I'm sorry.
position is you had no burden to satisfy.
Our position would be that we did not have to
Right,
go any
because you
further
had
in
a
terms of an
policy, and
evidentiary
the
hearing.
policy is,
A complete exemption equals undue hardship, according to the
Under
Cloutier case.
Under Cloutier. Let me ask you this. It has been pointed out that although Title VII and Chapter 151B are statutes that we often interpret sort of in sync, that they are different in certain respects. And in a very important initial respect, 151B makes it unlawful to impose a condition on obtaining or retaining employment that would violate someone's religious practices. Whereas Title VII makes it a violation to discriminate against someone with respect to their compensation terms, conditions, or privileges of employment. Those sound very different to me. 151B sounds a lot more limited than Title VII, is it not?
In the case of MBTA versus MCAD in January of 2008, this court indicated that there was very substantial similar ground and actually was not concerned about any differences between Title VII.
Well, what I'm getting at is this. I mean, the first thing that the plaintiff has to do is establish a prima facie case.
Yes, Your Honor.
Under Title VII, that's a prima facie case of an adverse action, which could include compensation, terms, conditions, privileges of employment, any adverse action in any of those areas. At least 151B really doesn't speak in terms of that. It speaks in terms of imposing a condition imposing a condition for purposes of getting employment or retaining employment. And I take it no such condition was imposed here.
No such condition was imposed here. And
the policy imposed a condition.
I'm sorry, Your Honor.
The policy imposed a condition.
Not on retaining employment, though.
The policy respectfully contained its own reasonable accommodation because there were many individuals who either had mustaches or beards that were employed at that time when the policy was implemented. And F.L. Roberts was sensitive to that, so it indicated that Mr. Brown, along with a half a dozen other individuals, could still remain employed. In fact, Mr. Brown's first question to us when we handed out the new handbook was, well, does that mean I no longer have a job? And we indicated, absolutely not. You and the other half dozen individuals absolutely have a job. It's just that based on our statistics, our information, customer contact individuals should be clean-shaven.
You said our statistics. Which statistics?
I'm sorry, Your Honor.
You said based on our statistics. Which
Based on-
statistics?
It was based on information that a consultant...
Was that information proffered by the company?
Not the specific statistics. It was proffered
Was
in the
the
sense that it
report-
was...
Was the report proffered? Was there a report from the consultant?
No, it was not, Your Honor. But
What
the information...
What exactly was it?
It was information that really demonstrates the mindset...
No, I just want to know, what was it, a conversation?
It was a conversation, Your Honor. And it showed
Was
the
it a
mindset...
conversation after information had been provided to the consultant?
Was it a conversation after information had been provided from the consultant to Mr. Smith, the Vice President of Operations? Yes, Your Honor.
No. Was it a conversation after the company had provided the consultant with information?
I don't think I can answer that question, Your Honor.
Was it a conversation relating to this particular industry?
Yes, it was. It was related to this particular industry.
I thought you said Disney World was part of that.
There were analogies to Disney World, Judge.
And
where
what was the information?
The information was that the statistics of this Power Inc. group, the research that was done by this entity, showed that the majority of customers...
Of what?
In the retail business.
Any retail business?
In any retail business.
So it wasn't specific to this retail business?
It was not. It was
there was
not.
no information about this retail, but it was the retail business in general.
It was the retail business in general. That customers... Now, we have to keep in mind that what Mr. Brown, had he maintained his customer contact, this is a gentleman who was a Rastafarian who did not shave his hair and did not cut his hair and did not shave. And he would have been the individual, as you're pulling up in the Jiffy Lube, as you're pulling up towards the bay, he would approach you and try to sell you more services than you would have otherwise intended. So if you only wanted an oil change, then he would have tried to sell you more services. Our feeling, F.L. Roberts' feeling, was that people would be more likely to purchase more services from individuals who were more conventional in their appearance, who were clean-shaven. And that was part of the motivation behind the enactment of the new personal appearance policy.
I'm sorry to interrupt you, but when
I'm
you
sorry.
say it was evidence of Mr. Smith's mindset, but the issue isn't his mindset, the issue is undue hardship, right? I mean, this isn't the claim, nobody's saying here that there's another reason for what they did. It's just, it's whether that is admissible evidence for summary judgment purposes of undue hardship on the part of the company. Isn't that right?
My understanding of the law, Judge, would be that once the court, Judge Josephson in this case, Judge Ponser prior to her, makes the determination that it's a complete exemption that Mr. Brown was looking for, and
I think
that...
anyway, go ahead.
I'm sorry,
I'm
Judge.
sorry, go ahead.
Once that determination is made that it's a complete exemption, and that consistent with the law that's repeatedly been held, that private employers do have the right to control their public image, that by necessity, that's an undue hardship under the law. And again, citing Cloutier, which this court, you know, has certainly suggested should be considered in cases of religious discrimination such as this. So the complete exemption and the fact that a complete exemption would equal an undue hardship, and that private employers have every right to control their public image. And if you think about it, it would be a chilling effect.
Your time is up.
Thank you so much.
Thank you, Ms. Thompson.